Welcome everyone, and thank you for joining us for reducing your exposure to PAGA and class action claims. My name is Nicole, and I will be your moderator for this session. Throughout the presentation, please type your questions into the Q&A feature found on the right side of your screen. The last 10 minutes will be devoted to answering your questions. We also invite you to use the chat to engage with each other, but please keep questions for the presenters in the Q&A. Thank you all, the Ag Labor Forum sponsors, for their support, and our presenter, Jim Gumberg, is an attorney with Patane, Gumberg, Avila, where he heads the firm's labor and employment law department. He handles all facets of the litigation and trial process, wage and hour employment disputes, and has extensive experience in defending small, mid-sized, and large companies in wage and hour class actions, PAGA claims, and single plaintiff wage and hour, wrongful termination, discrimination, and harassment cases. Jim received his BA from the University of Florida and his JD from Santa Clara University, where he was a member of the Santa Clara Law Review. With that being said, Jim, I will hand this over to you.
Thank you, Nicole. Good morning, everybody. I'm hoping everybody can hear me okay. This is, of course, always doing the first presentation of the morning has its challenges. So you guys trust me, you don't want to know what's been going on here the last half hour. So, but we're all on and all is good. So today we have a lot of material to cover, and I don't know if I'll be able to cover it all, and I doubt it, but I have it in your slides, and you should have your presentation in PDF. So if we don't get through everything, because according to Lupe, we have a very hard stop at 9:50, and so I have to be mindful of that. So we might not hit all the topics, but I'd rather not rush through something that someone finds of interest. And so if that comes up and we don't get through everything, at least it's in your materials. So the topic today is PAGA, which is the California Private Attorney Act, and how it relates to class action claims. And so we're going to talk a little bit about the difference between the two laws procedurally and how they apply. And as labor contractors, part of your biggest issue is that you have a lot of employees. So the three groups that we run into the most that have PAGA claims and class action claims are labor contractors, restaurants, security guard companies, and a little bit with janitors. So I would say between the security guards and the labor contractors, they're the top choices for PAGA claims. And I would say the reason is because you can have explosive growth in those two areas without a large amount of capital infusion. So like, for example, if somebody wanted to start a factory, right, and you want to get to having 200 workers, it's going to take a large amount of capital and a large amount of time to build that. But if you're a security guard company, labor contractor, janitor, maybe a restaurant, you could have a lot of employees in a very short period of time. And that's the perfect toxic soup for a claim under either PAGA, which is the Private Attorney General Act, or a class action claim for wages. So PAGA is a very dangerous statute. So if you pick up anything out of today's presentation, I've reached a point in my career where I'm at a zero tolerance for pushing the envelope on possible labor code violations or possible practices that could be on the gray area, because it's extremely expensive to litigate a PAGA claim. The penalties are enormous, and frankly, it's extremely lucrative for the plaintiff's attorneys to take these cases. So PAGA has been around since 2004, and the theory is the state was so busy that they couldn't collect penalties against employers for violating the labor code. So basically they said, we're going to make all California employees essentially deputies of the Attorney General. So they could basically bring a claim on behalf of the state to collect penalties that are available under the labor code for labor code violations. So PAGA is not to collect wages, it's there to collect penalties. And the trick is that the state, if there's a PAGA recovery, 75% of the money goes to the state, right? Because it's right because you've made these workers deputies, you've made them agents of the state, and so 75% of the money that's recovered goes to the state for doing no work, and that's why these claims now are going to become very large, right? And so in order to have a PAGA claim, you have to find an underlying labor code violation. Here's a handy prop for today. This is the labor code. I buy this every year. I have this going back probably 20 years, and I keep it on my desk because I'm not that good at memorizing things, but there's a lot of material in here. So if there's a violation, alleged violation of the labor code, and that could be not having a compliant meal period policy or rest period policy, giving out a wage statement that doesn't have the right information, not paying travel time. Those are all, or not having suitable seating available for your workers. Those are all the basis for labor code violation and could be a PAGA claim, right? And so I'll just diverge for 1 second because I was thinking this morning as I was getting ready for the presentation that there's also a claim under PAGA for an OSHA violation, which is occupational safety and health. And I know we have a couple other speakers that are going to talk about OSHA violations, but there's so many different OSHA violations that could also result in a PAGA claim in the COVID era. And the things that came to mind are, not having hand washing stations available. You have an injury illness prevention program, right? Making sure that's been in place and making sure that's been given out to all the workers and having training for illnesses. And I was thinking a screening claim could be too, because now in the COVID era, under the CDC guidelines, there's screening protocols that have to be in place, right? Where you do a temperature scan and you're trying to catch somebody that's got the illness before they, theoretically can infect a whole bunch of people, right? But those could all form basis for PAGA claims as well. OSHA claims are a little different than let's say a normal PAGA claim. I haven't done very many. Every PAGA claim we have ever done, meal period, rest period, seating claims, overtime claims, not safety claims. But I was thinking with the COVID era that we're living in, we're going to see more claims related to workplace safety under PAGA. So PAGA is different procedurally than a lawsuit, like a class action lawsuit. So let's talk a little bit about how PAGA begins. It's going to start with a letter. You're going to get a certified letter. It's going to be addressed to the Labor Workforce Development Agency, which we used to call the Labor Commissioner, and now they call it the LWDA. And it's going to state the claims, the alleged labor code violations, and facts and legal theory supporting the claim. And so the way a PAGA claim starts is you'll get a certified letter. That letter is going to be mailed to you, and it's going to be mailed to the Labor Workforce Development Agency with the check for $75, and that starts the claim off and running. So when we say a claim is made by what we call an aggrieved employee, right? So the employee's got to basically, in other words, suffer the violation is what we always thought it was. So let's assume that I work on a crew and I want to say that I was denied the opportunity to take rest periods, or I didn't get my full rest periods. And then the lawyer's drafting up the PAGA claim, and then they find out that there's a possible travel time case that they can bring, right? But this particular worker didn't have to travel during the workday. They were stationed at one location only, right? Under PAGA, this case versus Huff v. Securitas, we found that as long as that person can come up with one labor code violation, here would be the rest period claim, right? They can now also bring a claim on behalf of any other labor code violations alleged that they can come up with against that employer. So it's called standing in our business, right? You have to have standing to bring a case. What we found out under the Huff case, as long as that quote aggrieved employee unquote can come up with one legal theory, I didn't get my rest periods, they didn't have proper seating, I didn't get paid my overtime, then they can bring a claim for whatever other labor code violations that they can come up with. So you get a PAGA letter. What's the first thing that you do? You really need to have counsel look at it immediately. I don't mess around with PAGA letters. And the main reason is there's a right to cure certain violations, and it's a really short window of time to cure. The one that we run into a lot is a wage statement defect. We'll talk a little bit about wage statements as the presentation goes on. But if there's a defective wage statement, and the two topics that are easy to mess up, you don't have the name and address of the legal entity that is the employer, and they don't have the dates of the period for which the employee is paid, right? So the beginning and the end date, and the name and address of the company, including the full legal name. So those are very common PAGA violations. And they came up with a cure period a few years ago that if you have a claim for those, you can actually fix it, issue new paychecks, and you don't have a PAGA violation. And you say, well, why do I care, right? And just in brief, and I'll get to this a little later, but the amount of exposure for a PAGA claim is enormous, right? It's $100 per pay period per worker, essentially, and then it's $200 after that, each violation. So just do the math, right? If you have 100 employees, you could have an enormous amount of money at stake. And the problem with agricultural workers, it's if there's a wage statement violation, it's per wage statement, right? And the problem with ag is everybody gets paid once a week. And so if you get paid once a week, you can have, 52 possible violations in a year. Let's assume you get paid twice a month, which you can't do in certain agricultural occupations. But if you could, then you'd only have 24 possible wage statement violations, and it's $100 per violation, right? So if you think about it from that side, you can see how the math gets up high very quickly. So without going too deep in the weeds, if you get a PAGA letter, don't sit on the PAGA letter. You really need to review it with a lawyer that's qualified, that knows the area and knows how to look at it. Because like I said, if it's got something in there that gives you the right to cure, you want to jump on and exercise the cure, because if you do it, then you can basically avoid any liability. The wage statement cure is a tough one because you have to basically issue new wage statements for every employee for every pay period. And our rule is we say you have to go back 3 years and do that. So it's a lot of work to be done in a very short period of time. That's why the leash is so short. And by the way, I was thinking about COVID this morning, and with COVID claims, if it's an OSHA safety claim, there's actually a correction period in there too. And it's a little different procedurally, and I promise I won't go too deep in the weeds on this, but for an OSHA claim, they have to actually submit it to OSHA. So an OSHA PAGA claim goes to OSHA and the employer and the LWDA. There's a cure period in there as well. And those claims go a lot faster because OSHA, if they think there's something serious, like you don't have a shade out there, you don't have water available for crews, that kind of thing. For agriculture workers, OSHA has basically 3 days to jump on it, and they will. And if it's something non-serious, they have 14 days to jump on it. And under PAGA, if they don't issue citations, then the employee can bring their own private lawsuit. So now let's talk a little bit about the differences between PAGA and class actions. Okay, so like I said, a PAGA claim is for civil penalties only. So you got to get that through your head. Civil penalties only, not for wages. A class action claim generally is for back wages, but they can also ask for civil penalties, and they do. So class action can cover both civil penalties and back wages, right? Examples of civil penalties that are available are minimum wage violations. Everybody knows what waiting time penalties are, like you don't issue the final check on time, that kind of thing. Those kind of civil penalties will go right to the worker. And so it doesn't go through the PAGA process. But if you have a class action claim and a PAGA claim, certain civil penalties go right to the workers, certain civil penalties have to go to the state. So you can see what a mess it is. And once in a while, oh, by the way, you can get legal fees under both class action claims and PAGA claims. So, you have an underlying violation. Let's say that we do all the math and the worst possible day, let's say it's 100 employees, it's $100 per employee, that's $10,000. But the plaintiff's lawyer can tack on their legal fees as well. So you always have to worry about getting hit not only with having to pay your own lawyer, but you got to pay somebody else's lawyer. So back in the day, 5-10 years ago, we really wouldn't see very many PAGA only claims. They would file a PAGA claim and a class claim together. So you get that PAGA letter, the time, elapses, the 33 days, then there's a civil lawsuit filed, and the civil lawsuit will be covering both claims under PAGA, which stands for Private Attorney General Act, and a class action claim. So they kind of both, most of the time they would run together. But once in a while, and usually it's with smaller employers, like let's say there's a restaurant and they only have 25 employees. We had a case once, and without going too deep on war stories, restaurant tips, it's a whole area all in and of itself, right? The tips belong to the employees. The tips do not belong to the employer. So what is the employer? The employer is an agent of the company. It's not just like the corporation, right? So let's say you have a 15 servers and they get tips, and the restaurant says, well, we want the managers to share in the tip pool, right? That's unlawful. That's a violation of PAGA, and that's the case that we run into. But because it's such a small group, they probably don't have what we call a numerosity. They don't have enough workers. So the plaintiff's lawyer would bring it as a PAGA only claim, because you don't need to worry about having to have a large group of people. Like I said, the mumbo jumbo word is numerosity. You don't have to have that. You just have to have an aggrieved employee. So the statute of limitations, I'm going to the next slide. So under a PAGA claim, the statute of limitation is 1 year. So that's because penalty claims only go back 1 year. Penalty claims can only go back 1 year. So if it's like a PAGA only claim, let's say it's for defective wage statements, they can only go back 1 year on the claim. Like the tip case, right, where you say that the managers shared in the tip pool and the money should have gone to the employees, and they want to bring a PAGA only claim, the penalties to collect on that, it'll be several different penalties that are out there, and it could add up to a lot of money, but it only goes back 1 year. On the other hand, if someone brings a class action wage and hour claim, right, let's say it's for failure to pay the right amount of overtime, denial of meal periods, travel pay, you can come up with whatever list you want. You can go back 4 years on that claim. So the statute of limitations for a wage claim goes back 4 years. The statute of limitation for a penalty claim goes back 1 year. So arbitration agreements. So Lupe, when we got ready for this, he said, make sure you talk to everybody about the arbitration agreement. So everybody should have an arbitration agreement in effect for their employees, right? And we're talking about a pre-dispute arbitration agreement, right? There's a bunch of requirements to have those agreements, like you want them to be enforceable, right? And what it does is it prevents an employee from bringing a claim on behalf of a group of workers in court. And I'll use the word claim because it really means class action claim. So if you have a good pre-dispute binding arbitration agreement, it basically shuts down a class action claim. And then the employee's got to pursue a single person claim only in arbitration, right? So that's a really powerful remedy to have. The bummer about pre-dispute binding arbitration agreements, the bummer is it won't stop a PAGA claim from going through court, because I don't make this up. All I can do is tell you what the cases say, right? So remember way back when, like 15 minutes ago, when we started the presentation, I said, hey, you're kind of a deputy, right? They say to the employees, you're a deputy for the state of California. So you're actually like a labor commissioner yourself, running out there, bringing these claims on behalf of who? All the aggrieved employees. But the state is really the party, because who gets 75% of the money? Anybody remember? Can't hear you. Oh, that's because I can't hear you because you're on mute, but 75% of the money goes to the state. So if you think about that, the state's basically a party to a PAGA claim. Unlike a class action claim where the money goes to the class members, even the penalties, remember we talked earlier, the penalty money goes to the class members. A PAGA claim, 75% of the money goes to Sacramento, right? To Governor Newsom and their group. And so the theory under PAGA is, well, wait a minute, Joe Smith Labor Company can't have a policy that prevents somebody from bringing a PAGA claim because that's a claim that's coming on behalf of the state. And so, it's kind of a glass half empty, glass half full kind of thing. I think the lawyers on the plaintiff side generally prefer the class action claim to a PAGA only claim or to a PAGA claim. But if they can't get that class action file because there's not enough people, let's say, they don't have what they call community of interest, then they might have to bring a PAGA only claim. So if you have the waiver in place, at least you're going to prevent the class action claim, which is extremely valuable. And I'll just say one thing on your pre-dispute arbitration agreements, we deal with these all the time. We write them, we litigate them. Like I said, the plaintiff lawyers generally don't like them and they will try whatever they can to challenge them and say that they're not enforceable because they have language in there that shouldn't have been in there, that's unenforceable language, or they'll say that the way it was given out was procedurally incorrect. We call it procedurally unconscionable. And so those can always be subject to challenge. So it's always a good idea, as you're doing like whatever audits that you do, to have somebody review your arbitration agreement to make sure that it's still current, still valid, because the one thing about this business is every time we turn around, something changes. There's a case that's coming down that's going to go a different way than everybody thought, and you're running around looking at all your policies. Arbitration agreements are always getting challenged. Always good to get them looked at. All right, so now we're going to move into the second part of the presentation, and that's going to be just different types of labor code. Everybody see the labor code? Different types of labor code violations that can create very large PAGA or class action liability. Okay, and so when you leave here today, I'm hoping you're thinking, oh yeah, that guy, that lawyer, Gumberg, he brought up a good point about travel time, or he brought up a good point about how we're supposed to calculate overtime. And so this part of the presentation, I want to spend a few minutes talking about what we see as lawyers, right? That's what I do for a living. That's what our office does. Cases that we run into commonly that are PAGA class action liability claims. So real cases. And I'm going to start with pay statements. And I never thought I would spend my legal career talking about pay statements and slaving over, wage statements every day, but it's a very large part of what we do. So believe it or not, because like I said, you have a large number of workers, you can come up with a technical violation under wage statement law, adds up to an enormous amount of exposure, which is very lucrative to the plaintiff lawyer. It's a lot easier, frankly, and I'll be cynical here, a lot easier to prove a violation of a bad or faulty wage statement, a lot easier to prove that as a labor code violation than to prove that Joe Smith Farming Company discriminated against a worker because of her protected class, like her age, her sex, her national origin, her race, her disability status, and all that. So that's why the lawyers, are much more interested in these kind of cases, because not only is the liability huge, it's way easier to prove. So I highlighted a couple areas, and you should be hopefully looking at this slide that talks about some of the things that we run into, particular to agricultural employers, labor contractors in general, specifically, right, that we see as pay statement problems. When I say pay statement, you all know what I mean. The wage statement, right? The bottom half of your paycheck, not the whole paycheck, but just the bottom half. So these are all the things that have to be on that wage statement, right? And so the one that you run into are piece rate units. So if you pay in a piece rate, notice number 3 there is all highlighted for you. You have to include the number of units and the rate. So the type of commodity that's being picked, the rate that's associated with it has to be on the wage statement. I know everybody can read, so I will not read through all these, but I just try to hit a couple of big ones. Number 8, the name and address of the legal employing entity. Remember I said that's one of the ones that you could correct. So on the bottom half of the check, the part that gets torn off, or if you're doing it electronically, it's still the bottom part. You know, if people are being paid like through paychecks, through electronic fund transfer, the bottom half has got to have the name and address of the company, right? Name, it's got to say Joe Smith Produce Company, comma Inc., and the address. And then all applicable hourly rates in effect during the pay period and the number of hours worked, right? So there we have, let's say there's a thinning rate, a pruning rate. Now you got hourly pay for that. So that's like $15 an hour. Those hours have to be put down at the bottom of the wage statement and the number of hours a person worked at the rate. And the same thing for the piece rate, right? So you have to put all the rates. If we pay like, let's say, a penny and a half per box in a cooler, it's got to be on the lower part of the wage statement. So what I've noticed is in the world of agriculture, which I seem to live in, everybody gets creative because there's labor shortages. The workers push back sometimes. And so they are constantly coming up with new things, new incentives, new add-ons, and those generally are legal, but it's just got to end up on the wage statement if it's a new rate of pay. For farm labor contractors, and hopefully everybody knows this, and please nod your head if you do. I'm looking for head nods. Oh, so name and address of the legal entity that secured your services. So if in a work week you're working for 3 different growers, which doesn't happen very much anymore, but back in the day it used to happen, all 3 names of the grower that secured your services, name and address, have to be on the wage statement. Paid sick leave, right? That's really supposed to be either on the wage statement or a separate writing. Most people don't give a separate writing out with people's paid sick leave, so that's got to be on the wage statement. Once in a while, you have exempt employees that don't have a cap on the amount of sick leave they can take. It's unlimited. If you have no cap, then for those people, you have to put like, unlimited on the wage statement or give them a writing that shows that. So let's back up to piece rates. So live and die in our world dealing with piece rate pay systems because they're frankly ripe for claims, and they're really, really hyper technical in the Bible here. And so constantly running into piece rate issues. So on the wage statement, from changes that came up a few years ago on payment of rest and recovery periods, if you're paying on a pure piece rate system, you're paying separately for rest and recovery periods. Those rest and recovery periods have to be on the wage statement and the rate that you're paying for that time, and the amount of money that the employees are getting for rest and recovery periods. So that's because, why do we do this? Why? Because several years ago, there was an enormous amount of litigation. My office was involved for a labor contractor on piece rate litigation. And everybody remember the whole safe harbor thing, that huge issue that came up a few years ago. We had a safe harbor case and went all the way to the California Supreme Court. And the reason the plaintiff pursued it is because there's frankly a lot of money at stake, and they're trying to get extra damages outside of what we call AB 1513, which was the new piece rate legislation that came in. And so what followed from the piece rate legislation is a change to the labor code, and now we know that the total hours of rest and recovery period has to be on the wage statement. Because why? Because you have to compensate the workers separately for rest and recovery breaks if they're piece rate workers. Non-productive time, same routine. I want to be mindful of your time, so I don't want to spend too much time on this. But NPT, remember, if it's a pure piece rate system, and hopefully I didn't misspeak on this, but any employee who receives a piece rate, even if it's like a bonus or incentive on top of the hourly rate, they would be separately compensated for the rest and recovery time, but not non-productive time. Non-productive time in the ag world, we talk about, it's a stretching in the morning, calisthenics, waiting for trucks to arrive, standing time while you're waiting, for things to happen in the field. And these are employees on a pure piece rate, right? So they're not getting a base hourly rate, right? They're getting a piece rate only. And a lot of people say, no, they get a base hourly rate. It's minimum wage. They get the higher minimum wage or the piece rate, right? Whichever's higher. It doesn't work like that because the non-productive time has to be paid if somebody gets a pure piece rate system. Even though minimum wage is the floor, it wouldn't be considered a piece rate plus system. So example of a piece rate plus system would be, Jim, you get $13 an hour to harvest celery, and on top of that, you'll get a penny a box that'll be divided amongst the crew, a group production incentive, right? That would be an example of an base hourly rate plus a piece rate, right? Those, in that scenario, you don't have to compensate separately for non-productive time. But if it's, you get, let's say let's say it's 4 cents for every box of celery, and it gets divided out amongst the crew, that's a pure piece rate system. Even though sometimes it might get, harvest goes low and then it goes below minimum wage or even an employer minimum, and then they say, well, you get $12 an hour if it falls below as your minimum. That, in my opinion, does not count as a hourly plus system. And if it doesn't, then you have to compensate separately for non-productive time. And then if you have to compensate separately for non-productive time, that as well needs to end up on your wage statement. So meal period premiums, and I'm trying to not rush, but I am trying to get cover a lot of material. So the wage statement, if somebody misses a meal period, misses a rest period, that hour of pay needs to be included on the wage statement as well. So I don't want to go too deep in the weeds here, but notice on number 18 where it says 1 additional hour of pay at regular rate of compensation. That's exactly out of the labor code, right? And I put in italics regular rate of compensation because we're going to talk about regular rate of pay. But there's a hot issue, and it seems to be resolved today through, not from the Supreme Court, but from an appellate court, that says, how much do you have to pay me for a missed meal period or a missed rest period? Is it my hourly rate of pay only, or is it my regular rate of pay? And they're two different things, right? And because the statute says regular rate of compensation, a favorable decision for the employers found that actually means essentially your base hourly rate. It doesn't mean your full regular rate of pay, which includes a whole bunch of other things that I'm going to talk about in a few minutes. Okay, so quick primer on rest periods. So we all remember the rule: authorize and permit, right? That's the statute. 10 minutes at least for every 4 hours of work. And the statute says major fraction thereof. Does anybody know what major fraction thereof means? Hello? Hello? Oh, well, I can't hear you. So I will say what it means is 2 hours and 1 minute. So that's what made, so if the time goes past 2 hours and 1 minute, meaning the work period, then the workers would be entitled to another 10-minute break. Quick example, let's assume it's a 10-hour workday. Let's throw the meal periods out the window for a second. So it's a 10-hour workday. Because it's 4 hours, 4 hours, and 2 hours, how many breaks would there be? 2 breaks. But if it goes, let's say 10 hours and 10 minutes, because you hit that major fraction thereof, because you're more than 2 hours, there would be a third break. So you have to be mindful of that third. And I know nobody wants to take the third break, so everybody wants to go home. But remember, we talked about PAGA. It's one aggrieved employee that can bring the claim. So that goes to what I said, my zero tolerance rule for these kind of things now. I don't mess around with it. I'd say give them the third break and make sure your foreman or foreperson, knows that you want them to finish less than 10 hours in the day, so you don't have to worry about the third break. Number 2, 3.5 hour day or less. If your total workday is 3.5 hours or less, that's one workday. I clock in at 8 a.m. I clock out at 11:15. There wouldn't be a break required because the total daily work time is 3.5 hours or less. Breaks are paid, you all know that. So one of the class action PAGA claims that we run into is, when does the break begin? Like I said, I have a zero tolerance for this. the break begins at the point of rest. So the fourth person should be trained that you don't start the 10 minutes until all the workers exit from the field and are at the point of rest. Point of rest is a term I use. It could be, the break room, it could be anything, but the idea is getting everybody in field work, getting everybody out of the field to wherever they take their breaks. And the premium pay for breaks is 1 hour of premium pay. So quick war story, I said this 10-hour deal, we litigated that very case where the employer was not authorizing and permitting a third break at the 10th hour of work. And we'll talk a little bit about recording rest periods. I found in the world of agricultural labor, everybody records breaks and they're used to doing it. I don't have a philosophical problem with it, but the law doesn't require you to record a break. It requires you to record a meal period. I go back and forth on this. I take the position now in our office, and things are getting better with automation and people are moving to better, more robust computerized record keeping systems, that you should record the break. Like I said, the law says you don't have to do it, but you should do it. The downside in doing it is what? Well, like I said, we had a client, it was a class action claim actually, where they said they didn't get their third break after the 10th hour of work, right? And so how did they try to prove that? Well, they got the employer's records and they looked through there and they got, we call them a crew sheet. Back in the day, even now, actually, they still write down the time on a handwritten crew sheet. It's got the start of work, it's got the end of work, it's got the time they took their meal period and the time they took their breaks. And the plaintiff's lawyers just went through every one of those and they found work days that exceeded 10 hours. And they noticed that on those days, there wasn't a third break given that showed up on the wage statement. So then we're getting in a position of trying to prove on my end, well, we offered the crew the right to take a rest period at the 10th hour. They just didn't want to do it. And then now you're in the rabbit hole of having to develop what we call evidence to support that. And it's not that easy to do, to get people to sign declarations or give testimony to say, oh yeah, I do always remember that our foreperson would come to us at the 10th hour and say, hey, do you all want to take another break right now? Or would you rather just work for 5 more minutes and leave? And the problem with that too, on number 3 there, I don't believe, and remember, you're talking to someone who's, I guess I'm talking, you're not talking, that from a very conservative approach, right, the rest period has to be authorized and permitted, right? In a crew, how am I going to prove, let's assume they didn't take a third break at the 10th hour, right? How am I going to prove that every single person on that crew decided that they didn't want to take a third break? Because in our world, a lot of it is group piecework. I don't know if you all are paying that way, but it comes up all the time. And let's say there's 20 people on a celery crew. I'll pick on celery for the day. Romaine lettuce crew. How am I going to show that every single one of them decided that they didn't want to take their third break? It's basically impossible. Sorry about that. All right. So now let's talk about on-call rest periods. And this doesn't really apply too much to agricultural workers, but I just thought I'd put it in there so that you know you're not the only one that gets picked on. Remember I said the top ones that we see get picked on for wage and hour PAGA class action claims are security guard companies, labor contractors, janitors, and then you have restaurants. So the quick story about on-call rest periods is you have to make sure that your employees are relieved of all duty during their breaks. The security guard company here, it's called ABM Security, they had a policy that said that the guard, even on their breaks, they have to be on call, vigilant, and at the ready. And so that was found to be an unlawful policy because they weren't free to do whatever the hell they wanted during their break. So be careful about the level of control that you have on your employees during breaks. Like if you tell them, I don't know, if trucks come up, you have to unload, you have, let's say it's someone is driving a forklift out there, those kind of policies to tell them that you have to interrupt your break whenever anything happens, work-wise, that would be unlawful, and I watch out for that. So moving on to meal periods, right? The basics of a meal period, it's what for every 5-hour work period, you get a 30-minute break. But if you can finish the job in 6 hours or less, then the meal period can be waived by mutual consent of the employer and employee. If the work period, remember it's work periods, right? 5 hours, if it goes more than 10 hours, what happens? You have to take a second meal period. So we talked about third breaks, and we have to talk about now second meal periods, right? So remember, your break is every 4 hours. Your meal period is what? Anybody? Every 5 hours, right? So the second meal period can be waived if the day is less than 12 hours. Both the employer and the employee agree to waive it, and they took the first meal period. That waiver needs to be in writing. Basics again, and I can't go too deep here, so I apologize. But you have to be relieved of all duty during a meal period, right? It has to be at least 30 minutes in length, and there's that point of rest issue. Recall that the meal period begins. My world, I would like there to be a policy that says meal periods begin at the point of rest. And again, that's not like a term that I use. It's probably a better word at the rest area, in the shade area, with tent setup, whatever word that you use for it. That's when the meal period begins. And so it's got to get drilled into the foreperson's head and the supervisors so that when they give their depositions, it just rolls off easily off their tongue. Meal periods are uninterrupted. Employees should be allowed to leave. You can't say everybody's got to take their meal period in this area, right? That's wrong, right? Everybody's got to eat at their desk, right? If it's a office format, because that's a recipe for a meal period claim, because the person's going to say, I couldn't leave my work area, so I never got my meal period. Got to record your meal period, right? So there's no two ways around that. You must record meal periods. So now let's talk about the premium. This is that penalty. This is the thing people get sued over under PAGA or under class action, right? So if somebody is lost a meal period, they missed it or came in late, you get 1 hour of 1 hour of pay for missed, late, or uninterrupted meal periods. Interrupted meal periods, excuse me. The premium's got to show up on the next pay statement under the statute. So if I miss a meal period this week, I'm entitled to my 1 hour of pay. And I have regular rate of pay here, but I think the proper term is regular rate of compensation. And so that would basically be at my hourly rate of pay, and it's got to show up on my wage statement. Can you get around not paying for a missed meal period or maybe a late meal period? So they take the meal period, let's say it's a crew and they didn't get it until the 5 hours and 25 minutes today. The question is why? Why didn't the group get the meal period by the 5th hour? If you can prove, and this is hard, by the way, but if you can prove that the reason the person, or let's make it easy on Jim here. Let's just say it's one person. The reason that they took a late meal period is for their own benefit. They wanted to leave at, let's say, 12:30 because they had a parent-teacher conference they wanted to go to, and they wanted to start their lunch at 12:30, right? And they started work, let's say, at 7 a.m. I'm not a math genius, but 7 a.m. to 12:30 is 5.5 hours. So we know that that is more than 5 hours, right? So that day, that person's owed 1 hour premium pay because they had a missed or late lunch, right? If you can show that it was for the employee's own convenience, right? They wanted to leave early. They had a parent-teacher conference to go to. There was some sale at Macy's that he wanted to go to, whatever it is, and they wanted to take a late lunch, and you document it. See, it says need contemporaneous documentation there. It's well documented. Then you can say that you didn't owe it, right? But again, it's going to be on you to prove that it was for the worker's own convenience and not the employer's. The last note there, I don't think that will work on a crew-wide basis. And again, that goes to what I said before, my zero tolerance policy for these now. I can't count how many times I can hear someone saying, Jim, they all said they wanted to work an extra half hour because there was a lot of crops, a lot of pick on celery. There's a lot of celery out there, and they were making a lot of money, and they wanted to work an extra half hour just to get to the end of the furrow, get to the end of the row before they take their lunch. I don't think that would work, because 2 years goes by. I'm looking at a crew sheet or looking at a daily log. It's going to show they started at 7 a.m. They didn't take their lunch till 12:30, which is 5.5 hours. I would need an enormous amount of documentation to show why they didn't take their lunch at 12. Like every single person on the crew agreed to take a meal period after the 5th hour. So, and it's basically impossible. And what's happened, like I said, in the olden times, like 2-3 years ago, they'd always want to get the equipment to the end of the row. So then on the break, somebody who's not on the piece rate crew can turn it so it can get started to go back the other direction. I wish I could say that would work, but like I said, I have a zero tolerance for these kind of things, and I think that's a risky behavior. All right, overtime, I'll talk quickly about the regular rate of pay. Just to say, the regular rate of pay is not the same as the hourly rate of pay. To calculate overtime, basically, it's two things. It's total earnings divided by total hours. And we all know agriculture now, and I'm assuming everybody here is governed by Wage Order 14, now has to pay weekly overtime. Thank you to the governor, right? Which is a huge, huge shift of how things have worked in the last 20-something years. I've been doing this, right? So in the olden times, it was time and a half after 10 hours, and that was it. No weekly overtime. But now, obviously, it's the overtime rules are shrinking, and then in 2 years, it's going to go to this very same 8 hours a day, 40 hours a week for agricultural employees, like all other workers. And so it's the weekly overtime that people run into the problems with. So if you're paying the overtime, it's total earnings divided by total hours. And what do we include in total earnings? All this stuff. Piece rate earnings, if there's a commission, if there's a production bonus, shift differential pay, on-call pay. If you're providing meals and lodging, getting away from H2A is not H2A, but as part of their compensation package, you're giving them a free lunch, that gets included. So does a bonus get included in that? Certainly a group production bonus system, like if you harvest a certain amount of crops, then you get this bonus, that would be included in the regular rate of pay. But it's a purely discretionary bonus. A Christmas bonus, a holiday bonus, it wouldn't get included, okay? Wanted just to make sure to clear up this. On the wage statement, we talked about that. The 9th requirement is you have to have all applicable hourly rates in effect during the pay period and the number of hours worked. So the overtime rates also have to be on the pay statement. Talk a little bit about travel time, and I know my time is coming to a stop here. Extremely hot issue in our world is travel time, right? It goes back to this case called Marillion that came out of Salinas, actually. If you're voluntarily traveling on your employer's buses, it's not hours worked. Now, everybody may or may not, I don't know if you're H2A workers, but there was a bill that came out last year. The governor vetoed it. They wanted to have mandated paid travel time for H2A workers, even if it's voluntary. So the key with bus travel, right? You have to have a policy that says it's voluntary. You don't have to ride on the employer's buses, right? Even though the governor vetoed SB 1102, I think travel time is going to continue to be an issue. And I'll just, two quick points on travel time. One, you got to have a policy to say that it's voluntary. And if people don't ride the bus, there has to be some way that they know where to go. There's got to be a policy that it's not a de facto involuntary travel policy where you must ride the bus, right? They have to know, like, tomorrow, this is the lot we're going to be in, this is the field we're going to be in, this is the time we're starting, and you want to take your own transportation, you can. I think you really need to have a robust travel time policy to make that point clear, because back in the was it Henry Ford, they made Model T, they said you could have whatever color you want as long as it's black. So it's like no choice, right? With travel, from the lawyer side, we need to be able to show that there was a choice given to the workers. So this is another issue that I think is going to become more and more important in agriculture, especially we talked about class actions and PAGA claim, and that's excessive travel time. So if you're a a union carpenter, for example, and you're working for a company that said, hey, and I live in Salinas, so Jim, we want you to go from Salinas to Santa Maria today to do some work down there. That's excessive travel time, right? That's got to be paid time to the carpenter. And maybe if they're even going outside of their normal commute area under construction, those people, as just a general rule, they're paid extra money if they travel, let's say, more than 30 miles out of their from their normal, from their house to more than 30 miles to a job site. They get extra pay. It's considered paid time, and that's very common in the construction industry. Not so common in the agriculture industry. Nicole, not so common in the agriculture industry. So I think what it's going to come up if people were traveling, an hour on a bus to go to a work site and work for 5 or 6 hours, 7 hours, 8 hours, an hour back. I would be very cautious with those, and I think that's something worth evaluating to decide if it's excessive travel time and whether people should get extra. All right, so 9:51. I know that we have to have questions and answers, and so I was supposed to stop.
We have a couple of questions for you. Thank you so much, Jim. So somebody had said, I've recently seen new hires challenging the requirement to sign an arbitration agreement. Flip side, mandatory as a condition of employment. Do you have any recommendations on how to explain this to the employee?
So, okay, yeah. So remember, the arbitration agreement, it's got to have two things, right? It's got to be substantively okay and procedurally okay. And what that question is asking is it a procedural problem, right? The way you distributed that arbitration agreement. I think they need to be translated. If your workforce is, let's say, predominantly Spanish speaking, you got to translate it. And I think you have to have individual or group meetings. And I say every year that employees come back, they need to sign the arbitration agreement each season. Does that answer the question, Nicole?
Yeah, we're good. And then if PSL detail is incorrect, is this subject to a PAGA claim if filed by an aggrieved employee?
So I don't have the right paid sick leave on the wage statement. Let's take it that. So in theory, it could be. The good news about that is it's unlikely that's going to be governing, a large amount of people. So hopefully that's an individual claim only. I haven't had that case yet, but definitely since the labor code tells us that paid sick leave should either be on a wage statement, right, or on a separate paper, separate statement given to the employees. It needs to be correct on the wage statement as well. I think the good news is it's unlikely that would be some kind of group thing that would apply to hundreds and hundreds of employees. It's probably a one-off system. So hopefully it wouldn't be a PAGA claim, and if it is, it would only be on a very small amount of people. Problem with PAGA, like in class action, right, and these things is that you're talking about one little policy, but when you spread it out over a large amount of people, you can end up with a large amount of exposure. So I would, check your wage statements and make sure that the paid sick leave is tracked appropriately. But I think to the question, Nicole, I think, look, if I have, let's say, 30 hours of paid sick leave and I take one day off and it's counted against me for 10 hours or 8 hours, whatever it is, and next week's wage statement doesn't say now that I have 22 hours and it gets corrected 2 or 3 down the road. I mean, it's a very small violation because it's only, 1 or 2 wage statement. It's only one person. Anything else?
And then can a California PAGA claim be filed based on the federal CFLCA extended paid sick leave benefit?
That is an interesting question. I would say the answer would be no, because remember, PAGA is looking for violations of the California Labor Code, right? I think the FFGRA extended benefits, so somebody didn't pay it correctly or they didn't give it out, I think it possibly could be subject to a class action claim, right? But it wouldn't be a PAGA claim. Did we cover everything?
And then,
oh, sorry, Nicole.
Somebody had a question about the 10th hour. They want to know when would the employee need to take their break? Would it be before they clock out?
So let's think about the breaks, right? So every 4 hours of work, I'm entitled to what? One 10-minute break, right? So 4 hours, one 10-minute break. It's supposed to occur where? Somewhere in the middle here, right? What they say in the middle of the work period is as close as possible. So now we go to the 8th hour, right? So I start at 8 a.m. I take a lunch at 1 p.m. I'm going to take a break somewhere in the middle of the first 4 hours. And now I would get a second break after we come back from the meal period. We start it all over again. And now when we get to the 10th hour, I'm right in the middle of that third work period, right? I'd be entitled to a 10-minute break. So if you wanted to start it like if you think it's going to go more than 10 hours, I would start that third break at, somewhere maybe seven, somewhere, it's supposed to be the middle of the work period. So the theory is if it's let's say a 3-hour work period, right? They work, let's say 11 hours. So 1.5 hours between the 8th and the 11th hour, right? That's 3 hours. Half of that is 1.5 hours. They should take their third break. And so if it's a 10-hour day, probably the 9th hour, they should take a third break. If you think it's going to go 10 hours or more than 10 hours, I should say.
Thank you. And then if employees take 30-minute lunch and miss their lunch, do you still owe an hour for missed meal period?
Not sure I understand the question, but I'll do my best. So they took a 30-minute lunch. Is that what it said?
So the employees usually take a 30-minute lunch.
Yes.
And they miss their lunch. Do you still owe an hour for missed meal period?
Yes, it would be 1 hour. The missed meal. So you're saying I normally get a 30-minute lunch, but I miss it today. Yeah. So under the statute, it's 1 hour of premium pay. I wish I don't make it up. Yeah. So if it's a 45-minute lunch or 1 hour lunch or 30-minute lunch, whatever it is, and I blow through my lunch because I was too busy to take it, it's 1 hour pay. And remember we talked about it's got to be at the statute says regular rate of compensation. And I talked a little bit about the overtime rate. We still tell clients it should get paid at the regular rate of pay, which means that whole compensation for the week divided by total hours. Because I like I said, I'm zero tolerance guy, and I don't want to be the next test case. But there was a case, I think it's called Lowe's Hotel. It came out of LA that said that it's based on just their base hourly rate, essentially.
Thank you. And then if workers repeatedly have late lunch breaks without potential exception, how do you correct this? Disciplinary action leading to termination if persists?
Okay, so we have a labor shortage. I think the answer to that question is yes. I mean, I would like there to see progressive discipline in the write-ups. Hey, Jim, you're a mechanic, and I noticed you're taking a late lunch. You said it's because you're really busy, and we understand that. I'm paying you the 1 hour of pay today, but you need to take your lunch by the 5th hour. You have to do it. You have to do it. And this is a warning notice. And I started off by saying we have a labor shortage. Nobody wants to lose good people. The problem is in our world, if down the road there is these claims, I really like to look at pristine pay records. It makes our life easy. It's cheaper for you. You have less legal fees to your company, less time for you. It just shows 7 o'clock, 12 o'clock, 12 to 12:30, 4:30 they leave, and then it's just nice and clean. Second meal period. So anytime you get into these situations where people are consistently taking late lunches, it would behoove you to issue disciplinary notices and pay them for the time. Like I said, you're talking about a zero tolerance person here, right? Because I've just had so many of these cases. Our office, we have 7 lawyers that can keep everybody busy with these cases. So that's why I've reached a point in my career where say, I don't mess around with this stuff. I don't want to have to prove why the person took a late lunch on what particular day and what the reason was. Was it because of their convenience? Was it the company's convenience? And just to wrap it up, Nicole, I think the idea is if somebody didn't take their lunch on time because they're too busy to take it, there's a 0% probability that a lawyer can say that was for the employee's convenience.
Okay. And then if traveling 20 to 30 minutes from one field to another with no transportation provided, is that compensable?
Okay, so during a work day, right? I'm gonna assume I come in at, let's say, 7 o'clock, and then at 9:30 we move from one field to another, right? obviously, yeah, that's going to be paid time. If we tell everybody you have to go from field 1 on Harker Road to we're going to move down, it's going to take 10 minutes to get there, that will be compensable time. Yeah, so you would never want people to clock out for that. What they say is that the first site of employment would be considered non-compensable time. That's that travel issue we talked about. So the general rule is for me to go from my home to my first site of employment is uncompensable time. As of today, right? Who knows what's going to change, right? But once I get to that work site, and let's say it's a field, if I'm traveling throughout the workday to other fields, that's always considered compensable time.
Okay, I know we're out of time, but there's one more question. Is there a limit to meal penalties per day?
Is there a limit? Yeah, it's 1 meal period penalty per day, 1 rest period penalty per day. So the most you can get is 2. So if I missed 2 breaks today, or even 3 breaks, I just couldn't get a break at all, it's 1 hour of premium pay.
Okay, perfect. Thank you so much, Jim.
Well,
the session chat is still available after the session ends, so feel free to keep the conversation going. And again, thanks all again to all the Ag Labor Forum sponsors. Be sure to explore the exhibitor's booth, and thank you for joining us. Thank you so much, Jim.
Thanks all.
Thank you.